Hi there. If you're receiving this video, it's because you have contacted us or our office, and you've told us that you are in danger of breaching an agreement, specifically a new build agreement. You are not alone. In fact, we're making this video because we have this talk so many times a day now with Ontarians that we felt that we would take the time properly to do out this video and explain to you what the repercussions are and tell you a bit about your options. Because really, people feel very alone at this time. And before I even go into the law and the math and everything that goes along with it, it's worthwhile noting that, again, you're not alone in this regard. There are many Ontarians who are making this decision. And most of them are making this decision because as we approach 2026, 2025, 2026, and 2027, what we're seeing are the closings that are taking place from people who purchased in 2020, 2021, and 2022, which were the height of market. And so whereas in 2022, it may have made sense to pay $1,400 or $1,500 a square foot, now the market is showing that the value of products is somewhere around 900, 1,000, or whatever it may be that your product is at. And accordingly, even though you have significant deposits down, often 20% of a project, you are finding that notwithstanding that, you're still going to be in a loss position should you close. Putting more cash after the bad does not make sense. And so the question that you're going to come to us with is, should we do this? Should we close? Now, the very first thing that I am going to tell you is that what I am about to say is not legal advice. Obviously, this is a generalized video that I'm making to inform you of how to think about this problem, not giving you advice about your generalized situation or your specific situation. For that, you are going to have a discussion with yourself, with family members, and everyone else, and decide what to do next. But I can certainly give you some of the basic tools in understanding what your next steps are. So the very first thing to mention is that it is not illegal to breach a contract. It's illegal to travel 101 kilometers down the highway. It doesn't matter if your wife's giving birth in the seat beside you. It's illegal to punch someone in the face. It's battery. It's against the criminal code. It's illegal to trespass. It's contrary to the Trespass Act. It's illegal to do things that are contrary to the law, but there is no law that says that you must abide by a contract. There are consequences to not abiding by a contract, financial consequences to be sure. I'm not saying to you that it's consequence free. I'm saying it's not illegal. And because it's not illegal, your lawyers, your accountants, and others can help guide you through this process. If someone turns to me as a lawyer and says, hey, Mark, how can I travel 101 kilometers down a highway? I'm not allowed to give that advice. And for good reason. I'm not allowed to advise people as to how to break the law. But again, nothing illegal about breaching a contract, consequences to breaching a contract. And so the question that we therefore have is, should we breach the contract? Well, in order to do that, we have to first understand what the consequences are of breaching the contract. The consequences of breaching a contract are pretty dire, actually, in Canada. It's not like the States where you just have your deposit on the line, or in England, if you're from there, which has gazumping and a whole range of other things. You don't know what that term is, don't worry about it, you're not from England. But fish and chips is very tasty and you should try. But regardless, in Ontario, you're in for a penny, you're in for a pound. And what that means is that let's say that you've purchased a property for $1 million and the property value is presently $700,000 and you've put $200,000 down as a deposit. If you breach your agreement, if you walk away from your agreement, well, the $200,000 is lost for sure. The remaining $100,000 is something that the builder can pursue you for in court. Now, that's the minimum, because of course the builder, if they choose to pursue you in court, will in fact go ahead and pursue you not only for the differential, which in this case is the $100,000, because they already have your $200,000. That counts towards the damages. It's not only the $100,000. It's also their ancillary costs, their holding costs, that might have taken place over the course of time. If they have paid commissions that they can't get back, they may actually sue you for those. They may sue you for ancillary matters. Now, generally, when builders do sue, some of them are wildly aggressive, and they'll sue on the scenario that we've outlined for $300,000-$400,000. That doesn't mean that they'll make $300,000-$400,000. That just means that they're suing for that. Anyone can sue for anything. Practically, we're here to talk about what they will end up with at the end of the day. And what they will end up with is the $200,000 of liquidated damage, plus the $100,000 to account for the price differential, plus those damages that are reasonably expected from the breach of this file, which could be 50, 100,000, who knows? But the builder does have to prove those damages to the court. And of course, you can defend against that damage claim. There are two parts of a court action. The first is the establishment of a wrong. In this instance, if you are planning on walking away from an agreement, if that's the option that you choose, the wrong is very clear. You had a contract, you agreed to do the contract, you didn't abide by the terms of the contract, you're in breach. But the second part of court action is dealing with damages. And the damages are something that can be contested because they aren't just awarded as of right. Just because you won the legalities and said, hey, I actually have a wrong that has been committed against me, doesn't mean that you could then say, and therefore this person owes me $1 million. Heck, make it $3 million. No, you have to prove those damages before a court. And so a good deal of what your defense may very well be, if you are sued, will be dealing with the defense as against the damage claim, which, as you are now aware, based on what I've said so far, consists of the balance due and owing to the builder plus reasonable damages that they have incurred in mitigating their loss. Note that they have to mitigate reasonably. This is a general concept of law. There is case law out there that says that a builder, while they don't have a specific course of action to mitigate, does have to mitigate their loss appropriately. That is to say, they can't sell this product to their uncle for $200,000 when the market value is $7,000, and then claim damages of a further $500,000, because again, they already have their $200,000 on this million, and then there's a difference of $5,000 under this scenario. That would not make sense. Oh, 500, 600,000, I guess is the math. They can't sue you for an additional 600 because that's not reasonably mitigating their damage. So they have the obligation to reasonably mitigate their damage. So let's bring this all together. It's not illegal to breach a contract, and you're now aware that you are in hock to the builder for the original purchase price, which will include the deposits you've already paid, plus it involves reasonable damages predicated upon the builder's requirement to reasonably mitigate its loss. That's the generalized framework within which we are going to approach this. And so the question then you have is, well, okay, it's great that I know that, Mark, but should we now proceed to breach? Well, I cannot be the person who tells you whether to breach or not. No one can, because frankly, there's consequences either way. What I can do is, as I'm doing now, inform you of what you should be thinking when you make this decision. Before you, you'll see that I've provided a simple spreadsheet. I've just added it here. Let's deal with it accordingly. So we have two options here. Are we going to close or are we going to breach? So let's use the example of $1 million. Oops, not $100,000. Let's use $1 million. Okay, so in both instances, we have $1 million. And in both instances, we're putting down $200,000. Fine. And the market price in this instance is $700,000. Fine. That doesn't change in either scenario. Those scenarios are the same, whether you close or whether you breach. Now let's talk about what it would be like to close $1 million property. Well, the first thing we're going to do is we're going to just look up land transfer tax. Let's say that you're buying in Toronto and you're paying $1 million. So your land transfer tax is going to be $32,950. So $32,950. That's one of the closing costs that you're going to have to take on if in fact you close. Your adjustment costs on $1 million purchase, let's just use average adjustment costs, which are usually between about $10,000 to $20,000. They could be higher, they could be lower. Let's just say, you know what? We'll say 15,000. We'll say 50. Whoops, not 150. That would be too much. Let's say $15,000 is your closing costs. Now, you're going to also have, let's do occupancy. As you're aware, occupancy usually happens particularly in condo product, which is, by the way, where the acute pain is presently being felt. And for the purposes of a condoized product, for the purposes of occupancy, the occupancy fees can be fairly high. Because, of course, occupancy fees consist of three things: the taxes, the condo fees, and the balance still due and owing to the builder at the prescribed rate of interest. So, in this instance, you owe $800,000. You paid $200,000. $1 million is what's owing. 800,000 is remaining. And I happen to know what the rate of interest is right now, just to give you a sense. So I'm going to use 800,000. There we go, times 0.0725, which happens to be the existing rate, divided by 12 to give me a monthly. And that becomes 4,833 plus, let's say, taxes of, say, $600 a month, plus, let's say, condo fees of $400 a month. So we're looking at occupancy costs of 5,833. And let's say that occupancy takes place over the course of, say, 3 to 4 months, which is pretty normal. For a condo, I'll say 4. So our occupancy costs, if we close, in this instance, are $24,000. Once we close, we have holding costs. So really, the occupancy costs should be kind of here. Let me just make it a bit clearer, because the occupancy happens before the holding costs. Holding costs. There we go. And because I have a bit of OCD when it comes to spreadsheets, I will just make sure that we have, I don't want to waste time. Okay, you're just going to have to deal with the fact that it's not centered. Okay, so our holding costs. What are our holding costs? Well, if you're trying to avoid a lawsuit, and you're like most people, you're purchasing it and then you're going to sell it, well, you're probably going to therefore have to get private mortgage financing. Many of the people who are currently in breach positions, A, have properties that aren't appraising right. Some people never intended to close, never thought the market would go this way. And in most instances are taking a private mortgage. You'll have to determine what your particular circumstance is. But assuming you're getting a private mortgage on this, let's assume 7% interest is the way of things. So we're going to have to borrow 80%. So we're going to borrow, say, $800,000 times, that's 8 million. 800,000. Yes, 800,000 times, let's say 7% interest divided by 12 multiplied by 6. So I've taken $800,000, which is the amount of money you're going to have to borrow from a private lender or from a regular lender. I'm using 7%. It seems like a good average number because you also have to calculate lender fees of 1% or anything else. I'm just going to say 7%. So I'm taking 800,000. I'm multiplying it by an interest rate of 7%. I'm dividing that into the monthly rate, and I'm multiplying that by the amount of time you'll hold on to the property, being 6 months. Because if your goal is, like most people, to buy this and then to sell it, well, then you're going to care very much about when you can sell. And if you're trying to sell as quickly as possible, well, then you are going to ultimately want to schedule about 6 months, because it's going to take you about 3 months to get it on the market and get a sale. And then it's going to be 3 months from the time you sign your agreement to closing. So I'm estimating about $28,000 in your mortgage holding costs. Now, of course, if I wanted to be even more accurate than that, I could also add in your fees. So we have $3,000 roughly in condo fees and taxes, right? So we can add in, say, another, let's say $4,000, which constitutes, I'm just guessing, but it constitutes your condo fees during that time, and it constitutes your taxes. Your legal fees, if you close, will be both on the purchase and the sale when you sell. So let's call that $5,000 in total. And I've already dealt with your mortgage fees because I've called that your holding costs. But I'll write down mortgage, tax, and condo fees. Okay? Just because that way everyone understands what's going on. Then, of course, you have your commissions because you're going to have to sell this using a real estate agent to sell. So your commissions, if you're selling for $700,000 times 0.05, I'm going to just use normal commission rates. I'm sure you'll get 0.45. So we'll say 0.45 multiplied by 1.13, because you have to account for HST on commissions, is $35,595. So where are we? Well, we now have a sale price of $700,000. We already know that. Minus costs. So that's the amount of cash we have in. Minus costs of purchase. Costs of purchase. And so our costs of purchase are equals sum of these. So $143,000 are the full costs of holding on here. And we have put down $200,000. So we put down deposit previously of $200,000. And so if we were to go this route, the cost of closing is true cost under this is this plus this, meaning $343,878.33, but there's no lawsuit. That's how much it will cost, even though you're only $100,000 less because of all of these extraneous costs. We have effectively additional costs of $143,878. Does that make some sense? I hope it does. Now, as to what happens if you breach. Well, if you breach, you're looking at effectively no land transfer tax. You're looking at no adjustment costs. The builder doesn't sue you for adjustment costs. Someone else will pay that, whoever the new purchaser is. Someone else will pay the land transfer tax, whoever the new purchaser is. The occupancy fee costs, they may sue you for. They may very well sue you for. Now, you can claim that it's not owing. You can fight that in court, but it seems reasonable. And of course, the builder may very well sue you for your holding costs, as for their holding costs as well. Though the likelihood of them selling faster than you is good, and the builder also has the ability to claw back the commissions that they have paid to the original purchaser, original purchasing agent, the agent who represented you, meaning that there's a defense against them claiming commissions a second time. So you don't have any legal fees in this route unless you're going to count the defense, but we're going to leave that out. There's zero commissions payable, and your holding costs may very well be $32,000 again. Let's just be fair if the builder chooses to pursue you. And so what is the damage? Well, if they don't sue you, then the amount of money you're paying here is $100,000. That's it. You're paying, well, that's not true because you've already lost. It's $200,000 if they don't sue you because you've lost your deposit. If they do sue you, well, you know that they are going to sue you for that $100,000 difference, the difference between the 1 million minus 200,000 and then the $100,000 difference. Plus, they are going to have the costs, total cost. I'm just going to call this total costs. So the total cost that they're going to experience under this scenario is this plus this. And so what they're going to be able to sue you for is, so $700,000. And then the total costs, I'm just going to put another line in here. Sorry, I'm building this out as we speak. And we're going to say damages. So it's $100,000. And so the true cost then becomes the loss of your deposit plus the loss of your damages and the loss of your total costs. So $355,000 in this instance. And so, as you can see, by doing out the math, now that's only if you're sued, right? And they have to be able to sustain their occupancy costs and their holding costs and everything else. So as you can see, doing out this type of math allows you to properly track where you should go and how you should go. Look, it's scary. It's very scary to ultimately be in a position of breach. And whilst I can't give you any legal assurance that anything I've said is right or will be applicable to your situation, in fact, I expressly disqualify it. You cannot rely on this particular video for legal advice or to decide what to do. This video is giving you what goes on in a lawyer's head when you come into our office and say, hey, I have a problem I cannot close. The math has to be done. There has to be decisions made. They're difficult decisions, to be sure. And I really do significantly feel for those people who are in this scenario. More and more people, secret behind the scenes is that more and more people are in fact walking away. But knowing what the math looks like in your scenario, sometimes it's vastly different, is really critical to actually figuring your way through this, because the best way through is with information. The last thing I would mention, because people ask me this all the time, is will the builder come after me? Well, the way a builder usually chooses to go after someone is first they see if they have any assets on the land registry. It's an easy thing to search. You can search someone's name, and if they have an asset, you become a more lucrative fish for the builder. You are not allowed to transfer assets. There's something called the Creditor Protection Act. And the Creditor Protection Act specifically says that you're not, if you have expected creditors, you're not allowed to deplete your asset base in order to avoid those creditors. So no, there's no lawyer that can help you transfer out your titles, or I mean, I'm sure there are lawyers that will do it, but it's not legal. And remember when I was talking at the very beginning about traveling 101 kilometers down a highway, no lawyer could advise you to do it. Similarly, no lawyer worth their salt is going to be advising you to transfer assets or anything else, because that's contrary to the Creditor Protection Act. This is something where you have to stand tall and say, look, I have an obligation. This is what's happening, and you have to ultimately make your decisions accordingly. I do wish you the best as you go through this, and I do hope you've watched this to the end. And if you still have questions, I'm more than happy to kind of speak with you, and we can have discussions as to what to do next. But in the interim, I'm glad that you at least have this video that can at least introduce you to what's going on. And again, I'll leave you with this. You are not alone. Many people have made many bets on real estate over the past 20 years. Most have been successful, but we are in a market downturn, and it really sucks. You've been caught in a market downturn, and don't let anyone else tell you you're stupid or that it's born of ignorance. We all have to take chances in life. Some of us are lucky, some of us are not, and very few people can properly time markets. But that doesn't mean we don't have to do something very real to deal with here. And I do hope that you make it through to the other side. There is sunshine on the other side. I'm looking forward to seeing you there. Take care. Have a good day.